Welcome to the Safeguarding and Domestic Abuse sector for professionals working in the world of safeguarding and domestic abuse, and for anyone who believes in harnessing the power of sector-led learning and improvement. The conversation unfolds week by week, season by season. In this space, expect to hear me talk about this work which has the ability to change lives, alongside having powerful conversations with those who are taking action and can inspire us on our learning and improvement journey. This is the Safeguarding and Domestic Abuse sector. Hi, and welcome to this week's broadcast. This week, I wanted to talk about a development that has the potential to shape and change practice right across health and social care. And if you work in safeguarding adults, mental capacity, hospitals, local authorities, social work, or you're involved in safeguarding adult reviews, this is something you'll almost certainly be hearing more about over the coming months. So the Department of Health and Social Care has now published interim guidance following the Supreme Court's judgment on deprivation of liberty. And the guidance is intended to help practitioners begin applying the new legal position while more detailed guidance is developed. Now, this raises some big questions because safeguarding isn't simply following a legal test. It's about understanding what life is really like for the person sitting in front of us. So thinking back to the Cheshire West judgment from 2014, which introduced what became known as the acid test. If someone lacked capacity, was under continuous supervision and control, and was not free to leave, then they were considered to be deprived of their liberty. That decision dramatically increased the number of people requiring deprivation of liberty safeguards. And in many ways, it provided important legal protections. But over time, it also created enormous backlogs and significant pressure on local authorities and health services. So now the Supreme Court has revisited that position and the legal definition has changed. The government guidance confirms that the new interpretation applies immediately, while recognising that organisations will need time to adjust their practice. So existing DOLS authorisations should be reviewed as soon as practicable, but they don't become unlawful simply because the legal test has changed. So what does this mean for independent reviewers? Well, there is an opportunity because reviews have now never been about asking, did somebody complete the right form? They're about asking questions, why questions about practice. So what was happening for this person? Were their rights genuinely being considered? You know, where can we see the curiosity, the critical thinking? And when the legal threshold may have shifted, but our responsibility to uphold people's human rights has not. And one of the things I often see in safeguarding adult reviews is professionals becoming understandably focused on process. Was the referral made? Was the assessment completed? Was the authorisation in place? And of course, those things matter, but process should not replace professional thinking. So, also, as well as asking what the law requires, we need to ask, what does this person need? How restrictive are these arrangements? Have we really considered the least restrictive option? Can this person express their wishes? Have we involved those who know them best? And those questions remain just as important today as they were before this judgment. And I think one of the biggest learning points here is that the law is evolving and guidance is changing and case law is developing, but practice that is rooted in curiosity, proportionality, seeing the individual rather than simply the process is, the practice that we're looking for. And legal compliance doesn't automatically mean good practice. So sometimes reviews reveal practice that was technically compliant, but the person's voice was never really heard. Or professionals accepted restrictive arrangements because that's how it's always been. Or agencies stopped asking whether circumstances had changed. And those are the moments that reviews help us to uncover. Every new piece of learning changes the questions we're able to ask. So this is why being persistent, continuing to undertake our reviews, not kind of questioning the entire system and how we are making change when we can't see instant national results, is kind of, it's detracting from our effectiveness. The quality of the questions that we ask leads to the most meaningful learning. Now, our training for independent reviewers we will be welcoming an autumn intake in 2026, and that is exciting news, as I'd spent some time this year considering whether to only offer one intake. So there'll be an October intake. It's filling up fast because we've run a scholarship scheme. So if you would like to be assessed, please do click the link to have your eligibility assessed to see whether you're eligible to join. You will also see a link to just WhatsApp and have a chat with me. Thank you for listening. If this episode has been useful or enlightening, please leave me a review on iTunes. I'm always open to feedback, and I will really appreciate your review.